Thanks ever so much, Richard. Thank you. Darryl, if you wouldn't mind sharing the slides, that would be great. Thank you very much. So thank you, Richard. As you said, my name's Neil Ward, and I am a partner here at Mills Reeve. We are part of the health and care team, and specifically my work is regarding court protection work, which is what we're really going to talk about today. I'm very pleased to be joined by Emma today, Emma Edwards. Emma is from Together for Mental Wellbeing, and what we're going to do, as Richard said, is have about 20-25 minutes. I'm going to talk you through the main sort of areas of law, of this quite complex area of law, in fact, and talk you through that. And then Emma and I are going to have a discussion, a fireside chat, if you will, about a real life example and how this all gets applied in practice. And then we'll have a few minutes for questions at the end. So that's what's going to happen. Right. OK, so Darryl, if you wouldn't mind moving on to the next slide, that would be great. Thank you. Right, and the one after that. Thank you. Right, OK, so I'm really going to talk about three different ways in which residents and patients can be deprived of their liberty. And to start with, just to say it's a very negative phrase, isn't it? Deprivation of liberty, and it all sounds as if we're talking about sort of prisoners and that sort of thing, which is quite unfortunate. And one of the things that's been criticised over the years is the terminology. But at the moment, as the proposed reforms haven't yet hit the statute book, we are left with talking about them as deprivation of liberty safeguards. It is important to say, though, right at the outset, that although the terminology is somewhat unhelpful, all of this is, and the whole work of the Court of Protection is really aligned to the ethos of the Mental Capacity Act, which is all about trying to empower people and trying to give them a lawful and proper framework which they can be lawfully looked after and have their best interests at heart. And best interests really is absolutely central to everything that's about the deprivation of liberty safeguards and indeed the work of the Court of Protection. So the Deprivation of Liberty Safeguards, or DoLS as they are called, introduced as a schedule, somewhat unimaginatively named Schedule A1 of the Mental Capacity Act. And what it did was it filled in a legal gap or loophole which had existed previously, which had been exposed by the European Court of Human Rights some years before, where effectively, so people who are not falling under the Mental Health Act, so therefore were not mental health patients, were effectively being caught in a sort of legal no man's land between being completely free to do what they wanted, which they clearly couldn't on the one hand, and also then being formally detained under the Mental Health Act, which they weren't either. And so they were caught in no man's land between those two and unable to leave, but equally no lawful basis which they could challenge that. And so the framework was designed to give the legal structure, if you like, which would allow that, whilst at the same time giving them an opportunity to challenge it. And the essence, or the core, if you like, of the safeguards is the managing authority, which is either people like yourselves, so care home managers or hospitals, have the authority to deprive an individual, who is invariably referred to as P, of their liberty. It is really important to say right at the outset, this is completely separate from the Mental Health Act. You can think of the Mental Health Act and DoLS as like oil and water. They cannot mix. And we'll come on to one of the things that when you're looking at whether someone is eligible to be deprived of their liberty under the safeguards, one of the things is that they're not under a Mental Health Act regime. So this is entirely different from Mental Health Act. If someone is detained under the Mental Health Act, then these safeguards don't apply. Darryl, if we could go to the next slide, please. So the structure, as I said, the idea is that the managing authority is looking to the supervisory body, which is nowadays always a local authority, for authorisation. And in order to get that authorisation, you have 6 so-called qualifying requirements. First is age, so it's 18 plus only. One of the things that's being talked about in the reform is whether that should come down, and we will talk a bit later about what happens if someone's 15, 16, 17 and needs to be deprived of their liberty. But at the moment, that is an absolute blanket, so you have to be 18. If you're not 18, that's the end of it. Secondly, you have to be suffering from a mental disorder, and that links to the definition provided in the Mental Health Act, which is extremely broad. So it's pretty much any mental disorder. So it can be whether somebody has got dementia, someone has got learning disability, someone who's got a profound mental health illness. So whatever the reason is for that, it is covered. So that is a pretty broad church. The third thing is really important. So they have to lack capacity to make decisions on accommodation and care. And it is really important to realise that the DoLS, even when you get your authorisation, that only relates to accommodation and care. So it will authorise you to look after somebody in a place, usually a care home or sometimes a hospital, for the purposes of receiving care, but it does not, for example, allow you to take their phone off them and stop them using access to the internet, or stop them seeing a member of the family who you suspect is not good for them, or stop them having sexual relations with somebody. So it is purely about accommodation and care, and that's why the test is only restricted to that. So the person has to lack capacity to make decisions in relation to accommodation and care. Then the fourth criteria is really the linchpin of all of this, which is best interests. So it must be in the individual's best interest for him or her to be so-called detained resident. And you'll all, I'm sure everyone in this call will be familiar with the idea of the best interests assessor, whose role it is to make that very important assessment. And so that is really crucial, and it's from an outsider's perspective, it is really important to appreciate this is all done with someone's best interest. This is to protect people, for example, from wandering off, being run over, getting lost, or whatever. So this is intended to make someone's life who are being looked after in their best interests, so that they can live as fulfilling a life as they can in the circumstances. So this is not about coercive control. It goes without saying. This is about trying to do what's right for the individual. And then the last two are really making sure that, first of all, you've not got somebody who's under the Mental Health Act. And secondly, that it is in line with the Mental Capacity Act and the ethos and principles of the MCA. So eligibility criteria, it's one of the worst drafted bits of legislation. Everything is in double, if not triple negatives, because in order to be eligible, you have to be not ineligible. And there is a list or a table of 5 or 6 situations where, if you fall within the scope of the Mental Health Act, so in other words, for example, you are detained under Section 3 of the Mental Health Act, or you've got a guardianship order that requires you to reside at place A, and you're looking to apply for them to live in place B, then that would make that person ineligible. So the idea is it doesn't conflict with any Mental Health Act regimes. And so that's the eligibility criteria. But as I say, it is confusingly written. But broadly speaking, if someone is under the Mental Health Act, then this does not apply. And finally, because we're working under the Mental Capacity Act, the part of this is about giving people the opportunity to say, actually, I don't want that. And whilst they have capacity, they can make an advanced decision to say, actually, I never want to be deprived of my liberty under this framework. And provided you, as the care home manager or the hospital, are satisfied that that is a valid advanced decision, and it was made at a time when the individual did have capacity, then that is fine, and you have to respect that. You can also have a situation where someone who holds lasting power of attorney, usually but not exclusively a member of the family, objects. and says no, or a deputy, so a court-appointed deputy says no. So just a bit of practical advice on that. So our experience of these sort of things is that sometimes family members can come along and quite readily say, I've got a power of attorney and I object to that. And it is entirely right that you say, OK, that's fine, but I need to be able to see that. And there's no reason why you can't, because sometimes people are referring to powers of attorney. Actually, they're the old style powers of attorney, so it's enduring powers of attorney, or sometimes they relate to financial matters. And again, that's not relevant. So it is absolutely fine for you to sort of just satisfy yourself that objection is lawful and is correct. So if you satisfy those 6 qualifying requirements, which are the sort of the absolute fundamentals of the Deprivation of Liberty Safeguards, then you then can apply as the managing authority to the local authority to say, can we have authority, please? Darryl, the next slide, please. So you can make that application either at the time that the resident arrives or 28 days before. There are 2 forms of authorisation: standard, which can last for up to a year, or urgent. So inevitably, situations happen very commonly, in fact, where someone arrives perhaps unexpectedly, urgently, you weren't expecting them, and it is quite immediately obvious that they need to be deprived of their liberty straight away, and you've not got time to make an application to the standard or wait for a standard authorisation to come through. So in those circumstances, you as the care home, as the managing authority, can make your own application for urgent authorisation and sort of effectively self-authorise for 7 days, and you can get a further 7 days by agreement with the supervisory bodies. That gives you 14 days, but you need to be applying for a standard authorisation at the same time, and that will then come through. Provided all your assessments are positive, there's no discretion. The supervisory body will grant the standard authorisation, and what that is fundamentally then is a piece of paper, if you like, which says you are authorised and it is lawful for you to deprive this person of their liberty at X care home or X hospital, and it'll have a date, and it'll tell you very clearly how long that is. It'll tell you what to do when it's about to expire, and very commonly also they have conditions, which I'm sure many of you on this call will be familiar with. Things like this is fine, but you need to make sure they've got access to community a couple of times a week, or they have this particular therapy, or there is this particular support that's given, because this is really intended in line with the Mental Capacity Act ethos to be the minimum that is required in order to keep the person safe. And so this will be the least restrictive option. So they're up to 1 year. They can be less, frequently less, actually, and they will often have conditions which obviously you have to abide by in order to keep that authorisation lawful. Really important point, the final bullet point, and again, I'm sure many of you will have come across this, the relevant persons representatives, or the RPR. And because by definition this will only apply, this regime will only apply to someone who lacks capacity, it goes without saying therefore that they're not going to be, or very unlikely to be, in a position to be challenging this or in any way even understanding the process often, and therefore the role of the RPR is often a member of the family, sometimes a professional. Their role is to protect and to advocate for the interests of the person. And so in cases which we see coming to the Court of Protection, challenges to these standard authorisations come from the RPR, and they say the individual used to be in agreement, is no longer in agreement, or sometimes this person has never been in agreement, and we think that the standard authorisation is wrong. Circumstances may change, and they may well say, well, actually, I was happy living here. I'm no longer. I want to move. I want to go back home. I want to move to a different care home, wherever it may be. So the RPR is a really crucial part of this, because one of the criticisms of the previous case before this structure was brought in place was that the person had no means of challenging. So they were caught in a trap, as it were, where legally they had nowhere to go. They couldn't challenge the deprivation, and so this is very much intended to remedy that. Darryl, next one, please. So where does it not apply? Anything that is not a care home, so a CQC registered care home or hospital. So the most obvious gap is supported living, but also living with family, living in the community, living on your own with carers. All of those would not be covered. So anything that's not CQC registered. Also anyone who's under 18. Sadly, over the last probably particularly year or two, actually, we've seen a significant rise in these sort of cases, teenagers who are not under the Mental Health Act, so not detained. You can be detained at any age under the Mental Health Act. So these are patients who are not under the Mental Health Act, but who nevertheless need to be deprived of their liberty. You can't use DoLS, and therefore there is what's called the inherent jurisdiction. So you make an application to the High Court, and you get a High Court judge to authorise that. And as I say, sadly, we're seeing more of those coming through. So if you can't use the DoLS framework, then there are two routes. If it's an adult, you go to the Court of Protection. If it's a child, you go to the inherent jurisdiction. Thanks, Darryl. Okay, so what happens if you can't? So this is principally aimed at people who might have supported living, for example, or if you're a local authority and you're aware of someone living in the community, perhaps with their family, and you can't use the DoLS framework. So there are two routes. So when this first came out, there was only one route, and that was you had to apply to court. And when you applied to court, you had to wait for a judge to be available, and then that judge would invariably not make a decision the first time round. He'd send everyone away to collate more evidence, come back for a second or even a third or even a fourth hearing. And so it would go on enormously time-consuming process for everybody and very expensive for the state. And so that was quickly realised it was unworkable. So a few years ago, an alternative route, which is sometimes called the COP-DOL 11, which is the name of the form that you use, or sometimes the REX, which is the name of the case that instituted this route, that was brought in. And the idea is this can only work when everyone is in agreement, including the individual themselves. So the family, the carers, if there's a funder, the NHS funder, the local authority or the NHS, everyone's in agreement. And we as a firm, Mills Reeve, have probably got about 200 of these cases going through at the moment. So there's significant numbers, and obviously we're not the only law firm in the country. So, you know, there will be thousands of these going through the court system. So we are generally applying on behalf of NHS clients, but also local authorities separately will be applying as well. This is all, I should say, in relation to individuals who have got public funding or the public purse is in some way accountable. So these will be individuals who are perhaps funded by continuing healthcare, funded by the local authority, or in some other way are aware of, or the public bodies are aware of them. And for example, there have been case law where a local authority was made aware of an individual through safeguarding concerns, and then that became so-called attributable to the state. So anything that's attributable to the state, you need to go down one of these three routes, either this one, the REX, or the DoLS framework, or the one we're going to come to next. So what happens then is that under the REX process, there is quite a lengthy form that gets filled in. There are lots of people invited to contribute to that. So the family, the carers, you may well be approached if you're providing the care for care plans, etc. There's consultation and there's diagnosis, usually done by the GP. All of that is collated into one fairly hefty document that gets submitted to the court, and the court then approve it. I say the court then approve it. Up until recently, there was enormous delays on these cases, and it was frequently taking 12 months or longer for these to be approved. It has improved, I think, now, but nevertheless, you can still be waiting many months for approval to come through. But as I say, in broad terms, this is meant to be a quicker process because you're not going to court for hearings all the time. You're doing it all on paper. So that is one route you can do. That's if everyone agrees. And Darryl, the next slide. So the route 2 is everything else. So for whatever reason, the individual or anybody else for that matter disagrees, or that you want to go to court for anything else. So very frequently, yes, you want to deprive the person of their liberty, but also there are concerns with contact, for example, or there might be a concern about sexual relations, or there could be any number of things which would mean you couldn't use the streamlined process. And the court has got authority under Section 16 of the Mental Capacity Act to make a very, very wide range of orders, basically whatever it thinks is in the patient's interests to do that. And so they deal with that. As I mentioned a few minutes ago, we're seeing an increasing number of challenges under Section 21A of the Mental Capacity Act. So the RPR, on behalf of the individual, is allowed to challenge either the DoLS itself or some aspect of it. And we're seeing very significant numbers of these at Mills Reeve coming through. So challenges we act in this context largely for NHS clients. So ICBs, the commissioners are being challenged, and local authorities are as well under this. So this is patients or residents who are saying either I don't want to be under DoLS, I object, or I don't mind having restrictions, but I don't want to live here, I want to live somewhere else, I want to go back home, etc. And so those are significant numbers that are starting to come through. So this second part is extremely wide and quite a significant part of any court protection practitioner's caseload. Thank you, Darryl. So what does it mean for you? Well, first of all, if you have residents who are publicly funded or who are in any way known to the local authority and that sort of thing, you will be familiar with the DoLS safeguards and what your involvement will be, as I say, as the managing authority. So you are the ones making the applications. I think it's fair to say that you probably see less of the other types. So the REX, or sorry, there's a typo, it says 6, it means 16, as usually applications for court protection are driven by public funders, so the NHS or local authority. But you do have some involvement in that as well. Darryl, can I just go to the next slide? Sorry, go back again. I couldn't remember if there's one after that. Right. So I was going to say here, so I think that it is slightly unusual position for care homes to be in that there can be quite sometimes acrimonious court proceedings going on with the patient represented or the resident represented and the local authority, the NHS are involved, but the one people who are usually not a party is the care home themselves. And you may think that's a very good thing because you don't want to be involved in court proceedings, but nevertheless, it means you can be a little bit on the outside and you're the ones, as it were, holding the baby. So it is a slightly unusual situation. The most common times that you're involved, one is you may well receive an order from the court asking you or ordering you to disclose records, care plans, documents, etc., relating to the individual to usually the patient's representative, who will be either a solicitor appointed by the RPR or sometimes a body called the official solicitor. My advice to you in those circumstances, does happen quite often, is it can be a bit alarming. You get a court order and think, my goodness, what on earth is this? The main thing is to engage with the organisation, usually the NHS or local authority who sent it to you. Don't just sit on it and hope it'll go away. I would encourage you to pick up the phone or drop an email and start engaging, saying, I'm a bit worried about this, is this okay? I'm worried about data protection, I'm worried about patient confidentiality or residence confidentiality. What do I do? And we'd much rather have that engagement rather than a radio silence, because that's unhelpful. So that's the first thing. The second area of common involvement is evidence. And that can be really practical on, what is this person like on a day-to-day basis? Because the court can only be informed by the people that know that person best. And sometimes, very rarely, do you actually need to give evidence live in court. But in terms of contributing to the understanding of the parties and to the court of how that person presents and what care they need is really important. And that can be a second way in which care homes get involved in these sort of cases. So that does lead me on then, I think, fairly seamlessly to the next slide, please. Thank you, Daryl, which is my discussion with Emma. So we thought it might be helpful. You've heard me talking now about the court protection, the way it works, but really we were trying to bring that to life. What does this actually mean for you as care home manager? What's this from the ground, from the practical reality? So I think, Daryl, I don't think we need to carry on the slides. We can exit the slides if that's okay. And Emma, if you could pop your camera on, that would be brilliant.
Yep,
there you
I'm
are.
Here.
You're already there. So start with Emma. Let me just start by just asking you, just introduce yourself to everybody, a bit about yourself and a bit about Together for Mental Wellbeing.
Okay, hello everybody. I'm Emma Edwards. I'm Director of Operations and Quality for Together for Mental Wellbeing. We are the oldest community mental health charity in the UK. We were founded in 1879 by the Reverend Henry Hawkins. We have a range of services that include community support, criminal justice, and also CQC registered care homes, which is where the case study that we're going to talk about today is related to. So yeah, that's me.
Great. Thanks, Emma. So I think you're going to tell us about a situation that your organisation was involved with a little while ago. What was there with a particular resident? What was the problem that you faced?
So we had an individual who was referred and moved into one of our CQC services. They lacked the capacity to agree to the placement and also make decisions around their support and accommodation needs. Soon after they moved in, we experienced frequent incidents of very antisocial behaviour, and it became quite risky very quickly. There were assaults on other residents who were vulnerable adults themselves. Staff, we had a very serious incident of assault on a staff member. So it became really, really risky and very difficult for us to hold and manage as an unlocked community placement.
So that sounds quite a stressful situation for everybody. Yeah. And who did you reach out to try and unlock this problem?
So in the first instance, we contacted the referring social worker to express our concerns. We did keep them in the loop quite early on as soon as we started having these incidents, because as I said, they're very difficult to manage in unlocked settings. We also reached out to the funder, the local authority funder, and also the local adult safeguarding team, because we have a duty to report any risk to other vulnerable adults living in the care home, which were the assaults and the risk that was presented to them via the placement. We also reached out to the individual solicitor who was their representative under the DoLS authorization and also the court of protection process. The reception we got, we were very supportive from the referring social worker and also the funder. But obviously the solicitor was trying to block any move unless they could be absolutely assured that the move on accommodation was completely in line with what they needed, and also that there was no risk of that person becoming homeless, we did understand that.
So in terms of the responses that you got, the main issue was with the person's representative, and,
yes.
And from your point of view, putting you in a bit of a difficult situation in the sense of obviously having to look after him and not wanting to allow him to be homeless, but equally not being in a situation where your staff were being exposed to really unacceptable risks.
Yeah, and also our residents, our fellow vulnerable residents, there was assaults on them as well. And I think, we absolutely understand that that person is representing that individual and their needs, but it was the risk that was being presented to the other vulnerable adults that we had to manage and juggle, and it was very difficult to do that. And, so their priority is always going to be the individual. It's not going to be the broader risk of the risk that's presented to the care home.
Yeah, yeah. And how did the fact that the individual lacked capacity affect things? I think your organisation normally does sort of licenses for occupation and that sort of thing, but
Yeah.
the fact that this individual, didn't have capacity, how did that affect things?
I think it really protracted the situation because obviously, he had legal representation, which, we absolutely respect. And we also, the last thing we wanted to do is make anybody homeless, but also there's the risk that you're managing where, you can't manage the risk because we don't practice restraint. It's just an impossible situation to manage. So it really protracted it and it made it very, very difficult because obviously any placement that was found had to again be agreed to, and that was another kind of hurdle that we had to go through.
Yeah, no, I can understand that. And I suppose if a patient had capacity, you just serve notice, wouldn't you? And then as it were, that would be, you wouldn't want to see anyone out on the street, but I guess from, if you've reached the end of the notice period and they've said, well, that they've signed an agreement, they've signed an agreement. If they break it, then it's a contract, isn't it?
Exactly. And he wasn't able to sign that agreement. And also in other situations, the person does have capacity. So they've had that capacity to make those decisions, however unwise, but he didn't. So it did make it very difficult.
And I think one of the things that, just sort of reflecting a bit more widely, actually, away from your individual situation, that can often happen in these cases is exactly say we are solicitors for the NHS or the official solicitor representing the patient, very 100% focused, quite rightly, really, on that individual patient or the resident, but actually not seeing the bigger picture and the implications for other people. And from our point of view, more particularly from the solicitors for the patient or resident's point of view, that's fair enough because they're not paid to represent that person. They can't represent them. But of course, that translates into a really difficult position for you to manage then, doesn't it?
It does, because you're just trying to manage an impossible risk and, the impact on others, people living in the home, and then you can have people become quite unwell, people can be harmed, and it's just a really difficult situation for the provider. And also the team trying to hold everybody and keep things safe.
Yes, yeah. And we have seen providers really reach absolute desperation with that sort of situation. And although I don't think anyone would condone this, but, I guess I can understand it, people literally dropping off residents in A&E. And just, that's obviously, and then it really is over to the NHS usually that has to pick that up. So yeah, I don't think you quite reached that stage, but that was, I think I can understand how people end up being that desperate, really.
Yeah, we've never had to do that, and as you say, that would be an absolute worst case scenario for us. And I think what we did put in place did work. And actually, it took a lot longer to move the person on, but actually we were just really clear, and we just had, we put in extra safety mechanisms whilst we were waiting. So it did have a good conclusion in the end.
Yeah, I was going to ask you, so you were able to achieve a resolution then?
Yeah, absolutely. He moved on to much more appropriate accommodation. Obviously, it did become protracted as well because, to find alternative accommodation that would take somebody who had been really aggressive and did present a lot of risk, particularly he needed to be in supported accommodation or registered accommodation. And then the providers that were coming to assess have to be mindful of, the compatibility and the impact on other people. So I think, our top tips are, be really clear in an email in writing about the limitations of the service, which is what we did, that we will do our best to manage the risk, but actually we are limited because we're unlocked. We don't practice restraint. And I think that's really, really important. That's with all of the professionals involved, and especially when it's in writing, because then nobody could say, you haven't been clear with us, or you haven't let us know, you've missed something. And I think the other really important thing for us was raising the safeguardings, because again, that goes to the local authority so that they know what the risk is for everybody in that home, including the individual themselves, but also the other vulnerable adults that reside there. We also put in some extra one-to-one support, and we did that straight away, because we knew that we had, in order to manage and deal with any incidents that were brewing, we had somebody there who could diffuse the situation. Now, we had to initially just put that in, but we did get our money back. You know, the funder did pay for that, and this is the way that we always do it, because it's always safety first. We have to do everything that we can. You know, we've taken in that placement, we need to be responsible, and we need to make sure that everyone's as safe as much as we realistically can, and that did help prevent further incidents. But it won't always, but I think you've got to try it. And also, another tip that we would have is be proportionate in what you're going to put in, because ultimately the funder will pay for it, but it needs to be responsible. So, you know, we all know that local authorities and health are struggling financially, and it has to be realistic and proportionate. And I think as well, it was just contacting the police, because again, even though the person doesn't have capacity, there is a boundary there. You know, assault is a criminal offence, and you know, sometimes it can be difficult to get the police out because of the right care, right person legislation, framework, but actually they do have to come out if a crime is being committed. So, and I think that did work, and they moved on to other accommodation. As far as I know, it's been quite positive. So it was a good outcome.
Good. Good. I think one of the things that we were advising you right at the outset of this was your perception, whether or not in fact the local authority saw it this way, but your perception was that it was really your job to sort this out, and your job to find a new provider, which isn't right. But I mean, that was very much how it was put on to you, I think, from your perception, wasn't it?
Yeah, and I think we can get stuck in the middle as a provider, you know, and we don't have that ability. And, you know, we have to be a responsible provider. You know, we have to be open and honest about the incidents that have happened. You know, we want that person to have the right accommodation, the right level of support. So it is a really difficult balance to achieve. And, you know, you don't always get the right outcome either, but it was very challenging. But we were very lucky because we did have a good social worker that was involved as well, and she was very supportive. And as you say, we had the support of our solicitors, our legal team too.
Yeah. So in terms of advice to others, you said about be firm, be clear, making sure you're putting things in writing, involve the police if you're if it does become dangerous, really.
Yes.
And those sort of things, that they're the sort of main takeaways, would you say, from your point of view of experience?
I mean, complete a risk assessment. I think a robust risk assessment that's shared, multi-agency sharing can also help hold the risk, you know, because that, you know, and again, that kind of putting things in writing to all the professionals involved. You know, we've been clear about our limitations. What resources do we need from those external professionals and agencies in order to support us to hold the risk? It's that risk sharing that helps during that transitional period, however long it is.
Yeah.
And also the things that we can bring in, so extra staffing, because we've never not been able to get a refund on the extra charges that we've had, you know, if it's proportionate and reasonable, because to make it safe, because they have got a duty to make sure that everybody is safe as well as us. It's not just on us. Yeah,
and I'd certainly echo that from our perspective. I say in court protection proceedings, it would be a very brave local authority or NHS body that turns around to the court and says, look, the care provider are asking for, you know, X £100 extra for, you know, additional care, but we're not prepared to pay for that. I mean, the court would give them, you know, really no tuck at all with that. So you're absolutely right on that. I think one of the things that we see a lot in these sort of proceedings is a court's not understanding that actually the NHS, the local authority, don't themselves directly provide a lot of this care. They are reliant on providers like yourselves, and therefore, and there's a perception that from the courts sometimes and the official solicitor that sort of the NHS local authorities can sort of click their fingers and make things happen, but actually they are reliant on others like yourselves. But I think what probably doesn't get picked up as much is organisations and providers like yourselves that really try really hard and go the extra mile to try and look after people in sometimes really quite intolerable conditions, and that can go on for a long time and put on a lot of stress, because some of these cases can last months. You know, they really can, and it's not you know, that you do understand how people end up being quite desperate, or at least asking for an interim move to somewhere else, which can happen as well. Okay, thank you very much, Emma. I think, Richard, you've just popped up to say you've got some a couple of questions, which I'm sure we'd be happy to deal with for the next few minutes, if that's all right. Unless there's anything else, Emma, did you want to, or is that it, do you think, for the time being?
No, that's it. I think I've covered everything.
Thank you.
Thank you so much for bringing that to life, because I think it's really important just to hear a kind of a real lived example. And I think there's a couple of things you said there, certainly about, you know, having a good social worker. You were lucky. I think you were lucky. That's not the case in every situation. So it's a huge responsibility on care providers, you know, to have this sitting on their shoulders. So thank you for bringing that to life and helping. And we'll try and kind of bring some of those top tips into the FAQ that we send out, because I think they're really, really helpful. There are a few questions. The first one, Neil, if I just frame it, if a person has dementia and are compliant with their daily medication, and for example, you're unable to give them medication, they're probably unlikely to be able to ask for it. The provider's asking, do we need to do a capacity assessment for this? As I have seen some assessments completed because the resident is unable to manage their medication or ask for it.
Yes, I suppose broadly. So the question is saying someone has medication needs, but they're not able to, the individual themselves are not able to manage it. Is that right? Is that the question?
Correct. Yes.
Yeah. So yes, the short answer is yes. And if someone has capacity and you know, can agree and consent to that, then obviously that's the best thing. If they lack capacity, that can be a decision that's made in best interests. So you would not need to go to court necessarily for that, provided it is clearly in the person's best interest. If, however, you're verging into covert medication, that is something which you definitely recommend getting legal advice on, because that is a bit of more of a grey area. And so and usually you would look for court authorization for that, but that is quite a minefield, to be honest. But yes, broadly speaking, you would look to that, and if they lack capacity, then you'd be looking to give medication in best interests. Yeah.
Brilliant. And I think some of these examples, so the next questions were covered by what you and Emma have already talked about, but I'll ask them. This is, what are the options if you're not able to manage the disruptive resident?
I'll come to Emma in a second, but I think the short answer is, if you are absolutely unable to, you have to make it really clear to your funder, be that the local authority, the NHS, and you have to be really clear. And I think that the number one thing, I suppose, is to serve contractual notice. And so usually that's 28 days. So you need to get that in writing. I've seen many cases where care home providers have said in meetings, we can't manage with this, we really are unhappy about this, or send emails, but have not served notice. And I'm afraid public sector services being what they are, if you're not formally serving notice, they will, you know, gosh, sounds me. I don't mean they're taking advantage of it, but they will allow that to continue. If you've served notice, you've served notice, and that's a contractual thing. And as Emma said, I'll hand over to Emma to respond as well in a second, but you're just being really firm about that and saying, look, you know, 28 days from today, that'll be it. We're not going to do any more. And if you are finding pushback even after that, then seek early legal advice, I would say. Yeah. Emma?
I would agree. It's formal notice serving as soon as you know the placements become untenable and unsafe. And, you know, it's really difficult. Sometimes you just cannot manage the risk, but all you can do is your best and be very, very clear about the risk that's presented to everybody, again, in writing, in an email, and with the adult safeguarding team, the local adult safeguarding team, because if there's a risk presented in one of the care homes within their locality, they have a duty to support with a risk management plan. So it's sharing that risk where you can. And also extra staff can help. Waking night, it might be that you need to get a waking night in that can at least be present and respond and reduce the risk of another incident or any harm coming to anybody. But it is a difficult situation to manage.
Right, Emma, thank you very much. There's another question here in terms of, does our care home need to review DoLS processes and training, and how do we evidence compliance with the Mental Capacity Act during CQC inspections? Great question.
Yeah, yes, it is a really important thing, and I think it is something that CQC is interested in. So yes, certainly, and yeah, in terms of training, I think it is really important that there is an understanding not just of the DoLS framework but of the Mental Capacity Act more generally as well amongst all staff, because it is meant to be something which is not just applied at the sort of the upper echelons of managers, etc. It is meant to be something that's applied on a day-by-day basis, and by its very definition, the Mental Capacity Act is meant to be something that applies to all elements of life. So it is not just the big issues and the big questions. So yeah, absolutely. I think you definitely would. And in terms of evidence, in terms of showing that you've, going back to the question a few minutes ago about medication, yes, I think if you are concerned about something, evidencing that you've thought about it, that you've done an assessment, and clearly demonstrating that is definitely going to stand you in really good stead. And what we always say is that in terms of how to do that, just follow the really basic setup. The Mental Capacity Act is meant to be read, it is written in straightforward languages. And so, for example, if you're assessing capacity, looking for those 4 elements that are there in the Mental Capacity Act and just following those through. So it doesn't have to be an essay. It can be just a really clear evidence that you've followed through that, and that will stand you in really good stead. Emma?
Yeah, and I think again, documenting everything, having the measures that have been put in place in the support plan, in the risk assessment, that they're being actively, adhered to by staff consistently is also really, really important. And that, it's compassionate, support delivery, that, because it's how we do that in the best interest of the person and in the most, to support their privacy, their dignity, and their well-being whilst they're in your care home. I think it's really, really important. That's what a CQC inspector is going to want to see.
Brilliant. Thank you very much. I've got some more questions. There's another one just dropped into the chat from Amanda. There was talk about extending DoLS applications for longer than 1 year, as often we have to reapply and there are no changes. Is that still the case, Neil?
Yeah, it is. So the whole DoLS reform has been criticised. So DoLS has been criticised almost from inception, and has been sort of branded as effectively unworkable for years. But as I'm sure everyone on this call be aware, the government went out to a consultation last year, and there was proposals for the liberty protection safeguards, which was going to do a whole host of changes, including looking at that, also looking at making it applicable to safeguard supported living, applying it to 16-year-olds, and all of that has sadly been kicked into the long grass. But yes, there is that. The way it works at the moment is a year, and then you're right, yes, you do have to apply for that. I mean, in reality, we see quite a lot of standard authorizations that are less than a year, and it is a matter of individual sort of variation, really, but often there will be a sort of suggestion, well, this person may not get better, but actually in 6 months' time, with the right therapeutic support, maybe they could have a less restrictive regime. So I can't see a situation personally where they're going to say, okay, you're effectively just doing a one-off assessment, authorised for life or authorised for 5 years or so on. I think there is always a balance between the bureaucratic burden on care homes and on everybody by the system, but weighed against, I guess, equally, probably more importantly, was the desire to make sure that people are not just being rubber stamped and that's it for life. So I think it's a really difficult balance where nobody wants to add more work and burden to an already, significantly overworked sector, but equally we are trying to balance that against people's liberty and their right to be able to express that. I don't know, Emma, if you've got any thoughts on that.
No, I mean, I completely agree. I think it's a really important balance you've got to try and achieve. And I think, people can make progress. And, we've had people that have been on a DoLS for, this person just wanted to go to the pub on his own. But he would get lost and suddenly have not know where he was. And it was just balancing that and just having really person-centered risk management plans is really important. And that somebody, because ultimately what we want is somebody to be as independent as possible and not be on a DoLS. That's always going to be, the priority. But I do think getting the balance right and not rubber stamping people, as Neil said, is very, very important.
Thank you very much. I've got a few more questions. We find the local authority is slow at times, that we are renewing at 1 year before the council has responded to the first standard authorisation. And I think that goes hand in hand with another question, was how do you manage residents where there is an application to the court but no final decision been made?
Yes, so from a legal perspective, the DoLS framework, we if it's a standard authorisation, deliberately the lawyers are not involved in that. That's an application by the care home to the local authority, and ordinarily, unless there's a challenge, we as lawyers wouldn't be involved. But absolutely, anecdotally, we recognise that the delays by local authorities does cause a real practical problem. And in theory, the legal theory is once you've gone beyond 14 days, then you haven't got authorisation. You are just waiting for that authorisation to come through from the local authority. It's slightly different with court protection matters, in the sense that if it's a contested here, for example, you're applying for a contested, disputed authorisation, the court does have authority and frequently does, in fact, nearly always does, grant what's called an interim order, which will give authority right at the outset. So you issue the application, and within days, a judge will approve the authorisation on a temporary basis pending the court's final decision. That's the way it works. So you get an interim order that says the court has got prima facie evidence this person lacks capacity and it's in their best interest to be deprived of their liberty. So we'll order that for the time being whilst we then take the substantive evidence. So it's slightly perverse, isn't it? That's where it's contested. But if it's not contested, you're sort of caught in this legal limbo, really, which is very unsatisfactory, of course. And it's exactly the same, as I said, for the re-exes. You put your application in, and we've had cases that waited 12, 15 months, sometimes even longer for the court to deal with them. It's incredibly frustrating. Emma, I don't know if you've got experience of the local authority problem.
Yeah, I mean, I think as well, the advice would be that if you're acting reasonably to protect that person's safety and it's proportionate to the risk and it's documented in a risk management plan, it's really clear your rationale, I do think that that's generally supported. This is what I've always found. I mean, ideally you always want to have that, concrete authorization, but again, it's just if you're acting in that person's absolute best interest and the risks to them are so high, I think as long as you've again documented that and done a really robust risk management plan with a clear rationale, then you should be covered.
Brilliant, thank you. And there's one final question, which is, and I think you've partially covered this as well, but what are the consequences if a resident doesn't have the proper authorization?
Yes, so if you are depriving someone of their liberty without authorization, whether that's through the court or through the DoLS framework, then technically you are that is false imprisonment, and that is something which you can get the patient or resident can get compensation for. In reality, there have been very few cases where that's been applied by the courts, and the cases where there have been sort of cases where there's been absolutely barred or obvious failures by public bodies to respond. You've got families literally battering down the doors of the council house to say, I do not agree with this. You're holding my father, my mother against her will, his will, and I demand that you stop. And the local authority or the ICB, ignoring that for months or years on end. So there have been a handful of cases. The courts, in terms of compensation, the courts have used those extreme examples really to sort of set an example and say, look, this is unacceptable. And so there have been some compensation. I mean, we're not talking, we're not talking millions or even hundreds of thousands. We're talking about, 10, 20,000 pounds or something like that, which is sending a message, because the reality is that most, if not all of these residents would have stayed in the care home anyway for their own protection, their own best interest. So it's not as if you weren't keeping them in the care home, they would be, out in the community, living at home, enjoying themselves. That is not the case. So the actual loss to the individual is very modest, but the courts do occasionally, use those as a sort of an opportunity to set an example. But it is fairly modest. It is something that CQC are becoming more interested in, though, as well. And there are various pressure groups that are looking to raise this as an issue, because the reality is there are, the situation you've just described, Richard, for any number of reasons, not least the one you've just said about resources, court resources, local authority resources, etc. There are people, of course there are, that are, technically unlawfully deprived of their liberty. That is true. Emma, did you want to have anything to add to that?
Yeah, and also just to come back to, again, it's that safety. It's just safety, that person's safety. We would never want to do anything that would deprive anybody's liberty without having an authorization. It would only ever be if the person was unsafe while out, and because then you've got a risk of being willfully negligent as well. So again, it's really difficult for the provider to kind of make the right decision. But if you always focus it on that person's safety, everyone else's safety, then generally you make the right decisions that are reasonable and proportionate.
Brilliant. Well, look, just a huge thank you. I have just popped a note in the chat before we draw this to an end. If you do have a couple of minutes, just to write me a very short note to tell me whether you found this session helpful or not. I do want to say a huge thank you to Neil for putting together such a comprehensive sort of slide deck and talking us through this, and really Emma for bringing it to life, because I think it's really important for care providers to hear from care providers with real life lived experiences. So just a huge thank you. We will send a copy of the FAQ, just the questions that have been asked, with a very short answer, just to remind everyone what was said. We'll send you a copy of the slides, and we'll send you a copy of the recording, hopefully towards the end of the week. If you have any further questions, I'll make sure Neil's contact details are on there, and you can reach out directly. But just a huge thank you for everyone who's joined today, and a big thank you to Emma and Neil, as always, for taking us through that. Thank you so much.
Thanks.
Thank you.
Neil, are you okay to stay on?
Yeah, of course.
And Emma, if you